Vote rise.
Lowell versus Financial Services Commission.
Yes, Mr. Dunkley.
Good morning, my lords. Firstly, thank you very much for hearing this appeal. It is our first time in this chamber, and we hope that we will have a very good hearing today, my lords. I hope so.
Thank you.
My lords, I have a brief opening statement, after which point I would wish to take your lordships very quickly through the first aspect of the case for the appellant and then to the record of appeal to show you the salient documents that we're relying on. So, my lords, this is an appeal from Jamaica. Your lordships will note from the application for leave to apply for judicial review, as well as the amended fixed date claim form, those are found at pages 1 and 37 of the record, that the appellant sought orders for certiorari from the Supreme Court of Jamaica. His claim, my lords, arose from the notices that he received dated April 26th and July 1, found at pages 13 of the record. I'll take your lordships to that when we go to the record. At the time of receipt of those notices, my lords, the appellant had not yet received any word on his application for registration with the respondent, which had taken place in 2002, some 2 years ago, 2 years prior.
Can I just get the dates right?
Yes, my lord.
The application, so far as the appellant was concerned, was made by his company, is that right?
Made by his company.
And that was in the middle of 2002?
Middle of 2002.
Yeah.
And it's an umbrella application, my lord, because no single representative, no agent can file on his own. He has to be part of an ongoing entity, a registered entity with the respondent.
So the application has to be made by the agent's employers?
Correct, my lord. But he also puts in jointly an application in his own right.
And am I also right in thinking that the agent can't be registered unless his employer is registered?
Correct, my lord. Thank you. So the applicant's complaint, in short, is that there was a determination by the respondent after their own inquiries that he had breached the Insurance Act. And after that finding by the respondent, there was a meeting between the respondent and his employer, money, and the respondent thereafter offered the appellant two alternatives via the notices of April 26th and July 1. April 26th was an informative notice, and July 1 was the effective notice. And we say that he had that offered to him based on their own findings without him having had the benefit of a fair hearing. So the appellant's claim, my lords, was supported by a number of documents which were construed in part by one member of the full court of Jamaica as confirming that he in fact had the benefit of a hearing. This was Mr. Justice McIntosh, my lord. The other members of the full court accepted the respondent's position that the appellant was not entitled to be heard and that there was no ground for complaint at the time. The matter went on appeal, my lords, and there were two issues before the Court of Appeal. One, as it transpired, the respondent, this is without issue, had no force of law. They had no powers at the time because there was an oversight on the part of the legislature. And so the first issue before the Court of Appeal was whether the Validation Act of 2006 would have cured the actions of the respondent in 2004. The second issue that the Court of Appeal dealt with was a substantive appeal. And the Court of Appeal in Jamaica found for the respondent on both counts. So, my lords, if I may, I'd wish to take you very briefly to the case for the appellant, my lords. The filed case. My lords, the background says that this appeal arises from the dismissal of the appellant's application for judicial review of a decision by the respondent. The Court of Appeal unanimously upheld the full court's decision. The appellant was an employer of a foreign company whose insurance investment-based products were being sold to Jamaican consumers. There's no dispute that this activity existed prior to the passage of the Insurance Act 2001, and this act replaced a previous act.
Can you just help me again? If we turn to paragraph 5 of your case.
Yes, my lord.
Paragraph 5 starts by saying, having refused to register the appellant.
Yes, my lord.
Now,
I haven't remained in that position.
When did that happen?
My lord, my position from my notes here, I was not going to continue on that position. There was never a refusal.
Well, that's what slightly concerned me.
Correct.
There was
never a refusal, my lord, and I had picked it up and I had noted it to bring it to your attention when I went around to paragraph 5. Thank you so much, sir.
And am I right in thinking that at no stage did the appellant ever believe that he had been registered?
Believe that he had been?
Yes. Did the appellant ever believe that he had been registered?
The appellant believed that once he had filed his application along with the company, or the other way, the company, that permitted him to carry out the business of selling insurance.
I follow that, but that's not quite the same point.
Yes.
As I understand the papers,
yes,
the appellant never believed that he had been registered. He may have believed that he was entitled to carry on business,
yes,
but he never believed that he had been registered.
That is
that right?
correct. That would be my understanding.
But he couldn't have believed that he was entitled to carry on business because Section 70, if that's the right provision, says that you can't carry on business unless you are registered. And registered isn't simply a matter of filing the papers, because Section 74 has a procedure for a certificate of registration, and there's a whole procedure which is set out in Section 70.
My lord, what had happened in this circumstance, my lord Collins, is that there was a transition in from the old administration to the new administration. And this was a company, by the very affidavit of the respondent, recognized that that company had been operating for some time in Jamaica without being registered. This is the affidavit of Miss Holness. And thereafter, my lord, seeking to bring themselves within the ambit of the regulatory framework, they filed an application to be registered and filed for their representatives.
So are there some transitional provisions? Where would we find the transitional provisions?
My lords, it is not to be found in it was not to be found in any legislation. What we found, my lord, was the affidavit of the respondent.
Are there no transitional provisions in the legislation?
We saw none, my lord.
So what was the position before this Act came into force?
Before this Act came into force, my lord, there was no recognition that there was any, it was not unlawful for foreign companies to operate in Jamaica. So once you were working for a foreign company...
I thought you had to apply to the superintendent as well.
It seems as though, this is my understanding,
Where is the previous legislation?
Yes, the previous legislation.
Where is the previous legislation? Do we have it?
Yeah, we have the previous legislation. No, all we have, my lord, is the 2001 legislation.
So we want to know what the position was before that came into force.
Yes.
We have no material upon which to do so.
My lord, if I could assist, the affidavit of Miss Holness provides the closest assistance that I can direct your lordships to, which is found at page 44 of the record. My lord, addressing the matter of the old legislation, my lord, Ms. Holdis says at page 46 of your lordship's record, at paragraph 10,
Yes.
she speaks to the fact that even if the claimant was registered under the former act, he was required to re-register when the new act came into force, as the latter had additional new criteria for registration.
If you open paragraph 9 to us.
Yes. Yes, my lord. In processing the application submitted to the claimant, the Commission discovered that the claimant was not new to the insurance company as he had been previously registered by the Superior Insurance. That, my lord, would have covered the appellant, but not the company he was now going to be employed to. And he had previously registered by Superior Insurance to settle policy on behalf of Life of Jamaica. The claimant resigned from Life of Jamaica, as a consequence of which his registration to settle policies for that company was cancelled. The claimant subsequently registered to settle policies on behalf of Prime Life, that was also a registered entity, and Spectrum Insurance Brokers. However, the claimant subsequently left the employment of these companies, both of which filed notice of termination when the claimant resigned. The claimant then commenced settling policies on behalf of Malaika. He was therefore legally required to re-register, but this was not done. But to respond to...
So just on that last, when did the claimant commence settling policies on behalf of?
The claimant commenced settling policies on behalf of Malaika at a time prior to, at the time of the registration of the application for registration of both the company and himself.
No, when did he commence settling policies under the previous law?
Under the previous law, my lord, there was no registration of that employer, my lord, because they were
I'm asking about the employee, not the employer.
well,
so he becomes employed by M
yes,
before the new act comes into force.
yes, my lord.
At that time, he personally was under a duty to register with the superintendent. Is that correct?
No, that's not correct, my lord, because it is the employer that has to be registered.
About the previous law.
No, under the previous law, my lord, you had to be registered with an employer under both. But
Who applied for registration?
always the employer, but you have your individual registration as well. What happens, my lord, is that on his previous, his history as set out at paragraph 9. If you are working for an insurance company in Jamaica and you change, you alone will make an application to be registered for the new company. So when he worked for Life of Jamaica, he was registered to Life of Jamaica. When he moved to Prime...
Who applied for registration? Was it Life of Jamaica or was it him?
No, it would be him.
So it was his application?
Yes.
Paragraph 6 on page 45.
Yes. Under the former Insurance Act, the insurance companies are also required to register their intermediaries. It's a company. Yeah, but it's conjoined, my lord. What I'm saying is that you have an individual responsibility as a life insurance agent to register, but overarching must be that your company is a registered entity. Those two go together. You know, so you couldn't be a free agent as a life insurance.
I understand.
Okay,
What's
thank you.
not clear to me is whether these applications are made by the employer for itself and its agents, or whether there's a separate application made by the employee.
My lord, I'm considering whether anything turns on that in relation to the... Yes, in relation to the prior circumstance, because in the present circumstance, once the company was not registered, both would be reaching the Financial Services Commission at the same time. That was the unusual feature of what was happening.
So going back then, so that let's suppose there's no change in that respect.
Yes, my lord.
Then before this act the new act came into force,
Yes.
he had initially been registered through his previous employers.
Yes, my lord.
He then leaves his previous employers and works for MLICA.
Yes, my lord.
Under the then law,
Yes.
MLICA should have applied to the superintendent, is this right?
Under the previous law?
For them to be registered and for him to be registered.
My lord, as I understand,
About the old
yes, yes, the old law. Under the old law, as I understand it, my lord, and I'll take you to the affidavit of the.
If we don't know, well, let's just agree we don't know.
No.
This is my lord, the Henry Brooke pointed out a minute ago. Paragraph 6 says insurance companies were also required to register their intermediaries. It suggests that it's more or less the same system under the two laws.
My lord, the material that we have says that because it was a foreign registered company, my lord, they felt themselves to be in a lacuna at the time, which is why the new act came in. So under the old act, once you were selling foreign policies in Jamaica, they did not come under the regulatory ambit.
Where do you see that?
So I'm searching for that now, my lord, so that I can assist your lordship with that. Lord, I believe it was an argument. I don't see it in the affidavit, my lord. So we can move on from that point. I don't see that in the affidavit material. Yeah, you'll find it. My learned junior says she will look for it for me, lord.
And when was the old law repealed?
2001 was the introduction of the new law, my lord, at that stage.
Yeah, but my question was when the old law was repealed.
December 2001, my instruction, my lord.
What, as at the same time as the new law came into force?
Would have been coming into force, my lord. My lord, I would crave some aid from page 44 of the record of proceedings. At paragraph 4, my lords.
Now, was this affidavit sworn before or after it was appreciated that there hadn't been the relevant statutory instrument or whatever?
This affidavit was sworn before it was appreciated.
So we need to turn to something else to find out what the true position was. Where do we see the true position stated? What we can see in page 44 and so on is what was supposed to happen.
Yes, but this was the thinking, my lord. This was the thinking. This was the position of the commission. This was the thinking.
But do we have what was supposed to happen? Where is the provision which provided for a ministerial approval or whatever it was?
My lord, what we have is the validation after they realized that the lacuna existed, so.
Yes, but what was the error?
If we look at the Court of Appeal judgment, my lord, found at page 171, this judgment dealt entirely with the absence of authority for the Financial Services Commission, my lord. If you look at page 174 of that judgment, my lord, it indicates before us, both parties are at one, that at the time when the FSC purported to act in this matter, it had absolutely no authority to do so, because due to the neglect by the legislature, those provisions of the FSC Act giving the Commission authority to supervise the insurance industry had not been passed into law.
And are those provisions in the statute we have?
The validating act is in the statute. That
No, not the validating act. The provisions which were not passed into law. Which are they?
Yes. Technically. It's in the Board of Authorities. My lords, my learned friend assists me at volume 1.
Of the authorities.
1, the Financial Services Commissions Act. The definition, financial services means services provider offered in connection with insurance, acquisition or disposal of securities. This is what it has been.
The first schedule.
Okay. My lords, if your lordships look at the bottom, it indicates by asterisk that the provisions came into operation on the 4th of March 2005.
But which is the provision stating that it shall come into force on such and such a date?
That's at the front. My lord, there is a document that I do not believe was before the Court of Appeal. At the front of your joint bundle of authorities, this document, my lord. There's my flag on. Right, I understand. Right.
Oh, it's section 1.
Yes, before the Court of Appeal, my lord, that document was not what was before the Court of Appeal. What was before the Court of Appeal was tab 3.
Yes, but I'm a bit lost because it says the order says, in exercise of the power conferred upon the Minister by Section 1 of the Financial Services Commission Act 2001, the following notice is given.
Yes, my lord.
But there's nothing, unless I've got the wrong act. All that Section 1 says is the Act may be cited as the Financial Services Commission Act.
Absolutely, my lord. If your lordship looks to tab 3, your lordship will see what was before the Court of Appeal in Jamaica. And what was before the Court of Appeal in Jamaica. This is the Validation Act, my lord.
Well, that's true, but that doesn't explain, as my lord says, tab 1.
It doesn't, and that was one of the difficulties we had in this appeal, my lord, because we are saying that before the Court of Appeal in Jamaica, the only legislative reference was what is at tab 3, which starts in August 11th of 2006.
Leaving on one side what was before the Court of Appeal.
Yes, my lord.
I think, speaking for myself, I'd quite like to know what the position actually was. And speaking for myself, it would be helpful to us to identify the provision of the 2001 Act, which provided for its coming into force, and for its coming into force in bits. So are there any provisions in the 2001 Act about coming into force?
My lord, we were not able to see the force of that. This is why this was argued before the Court of Appeal in Jamaica, that the Validation Act was not, in fact, effective to operate as my friends were advancing at that time.
Is there something in the Jamaica Constitution that prevents statutes coming into force until something happens?
My lord, I would be going outside my area of competence to make that comment. But what it is, I'm a little bit ahead of myself at this stage, my lord. But I wanted to address your lordships on validation at the end of the appeal on merits, but we can attend to it now. We were going to argue this morning, my lords, that at the time of the full court, it was settled between the parties that the Financial Services Commission Act was not in force and they had no legal effect. Mr. Justice...
Well, the whole Act was not in force.
As it related to the insurance industry, my lord, as it related to their ability to act as they did on April the 26th and July the 1st, they had no authority to do so.
Sorry, no, carry on.
But therefore, it's very important for us to know which are the provisions in either of these acts which, in some way, delay their coming into force.
Delayed. Oh, to be interpreted in the way that the courts interpreted it and the parties, my lord. Because this is the reason why this act was considered to have been necessary. It was deemed to be necessary because there's an acceptance that the legislative authority fell short in regards to the insurance aspect of the Financial Services Commission. And if I take your lordship very quickly back to Mr. Justice Smith's judgment on
I think the
this.
first page of Mr. Justice Smith's judgment sheds a little light on it. Apparently, the Act came into force by virtue of an appointed day notice,
Yes,
but it omitted provisions relating to the insurance services.
yes,
We don't have the appointed day notice. In the authority.
my lord, at the time that this was argued before the Jamaican Court of Appeal, my lord Carr, the only legislative material that was before the court was what I took you to at tab 3. And so the effective date at the Validation Act, my lords, if you look over leaf, has in brackets 11th of August 2006.
So, which does tab 3?
Tab 3, my lord.
I mean, that does have a recital, it's true.
Yes.
That recites that on August the 2nd, the Act, other than the provisions relating to insurance services, was brought into operation.
And so to cure that, the Validation Act was passed.
And what about the Insurance Act 2001? Are we concerned with that?
The Insurance Act 2001 would be the governing legislation. That would be in force at the time, my lord. That would be in force. This is the powers to deal with the regulator. The regulator is the one who fell short.
But according to Mr. Justice Smith, the Insurance Act came into operation on the 21st of December 2001.
Yes, my lord.
And that's what the recital says on page 2.
So the Insurance Act was in force, but the power to police it, the power of the FSC, they responded to police it. They didn't get that power until the Validation Act.
But if we were to test the position before the Validation Act,
Yes, my lord.
and if a person was writing insurance without registration, would he be committing an offence?
My lord, if a person was writing insurance without being registered, that would be an offence under the Insurance Act.
Under the Insurance Act or under the Insurance
Under
Act?
the Insurance
Not the other Act. We haven't got the Insurance Act, though, have we?
You've got most of it.
Yes, yes, the Insurance Act.
How could he be guilty of an offence for failing to register with a non-existing body?
Well, this is the crux of the aspect of our appeal here. At the time, my lord, when the appellant applied, he could have done no more than he did, which was apply to be registered. His prospective employer, or in fact his employer, could do no more than to register. And the curiosity of it is that had the FSC licensed a person or even a company in 2002, say a month after they had applied, they would have no more effective license than the two entities who are awaiting a license because they had no force in law.
Could he have applied to the superintendent?
Superintendent didn't exist at the time, my lord.
Why not?
Because the FSC...
Where do we see the provision? Because if the new Act hasn't yet come into force for insurance purposes, because there's been no relevant appointed notice, why didn't the old Act still hold sway?
But they did away with the Office of the Superintendent of Insurance.
Where do we see that? You might be, I'm not saying you're wrong about it.
I understand.
But it's quite important because suppose this claim fails,
Yes.
suppose the application for judicial review fails, that your client won't have to pay the notice because he never had to pay the 100,000. He could just wait to be prosecuted.
Yes,
well, suppose he did wait to be prosecuted. His defence would presumably be, well, I didn't commit an offence at the time I did it. And I don't know whether there's any reliance upon the Validation Act there. Might be much more difficult.
Well,
But this is, if this case has got any reality apart from the fun of it for the lawyers,
well, my lord,
at this point we're now discussing it as of some importance.
My lord, it was always a case on its merits until the Validation Act point came up at the Court of Appeal stage.
Well, that's because your side didn't spot, and nor did they,
But
that the relevant bits of the Act hadn't come into force.
absolutely, my lord. But what, as I came in at the appellate stage before your lordship's board, the question I asked was the Validation Act the first time that the FSC became aware, and wasn't it a bill stage? And if so, what was their state of knowledge before the full court? Because they argued before the full court that they had force of law. And when we looked at the gazetting, my lord, we realized that the bill was gazetted in March of 2005, 1 month before the full court hearing. So we asked ourselves, at what stage did the Financial Services Commission appreciate that they were not grounded in law? And the document that has appeared at the start of the joint bundle of authorities, which is not referred to in the submissions for our learned friends, but is just there, and is not referred to in the judgment of the Court of Appeal, because we have no reason to believe. The lawyers on the other side instruct me that they had never seen this document until we got to your lordship's board. Curiously enough, has the date of March of 2005, 1 month before, to give effect to the respondent just prior to going into the full court. Because it is our view that once the Court of Appeal became seized of the fact that the Financial Services Commission were not grounded in law, then the judicial review would have been resolved in favor of the appellant then and there as a point in limine at the full court. And that the full court continued, as my Lord Collins has observed. Neither side picked it up. But I have to question whether it was only one side that didn't pick it up, because it was brought as an eliminate point in the Court of Appeal. It was never disclosed by the respondent.
But it's a very limited provision too, isn't it? It only refers to paragraph A of the definition of financial services and the fourth schedule, which is about penalties. So is there any commencement order in relation to the Financial Services Commission Act?
Matter for the other side.
That's the August 2001, that's right here, order, which omitted insurance services because one was waiting for the Insurance Act. And under section 70 of the Insurance Act 2001, which we have at tab 2,
Yes,
that provided that no person shall in relation to insurance business of any class carry on business unless he's registered under this part to do so. What should have happened was, having excluded insurance services under the August 2001 notice, which we haven't seen, there should have been a notice bringing the Financial Services Commission Act into force to coincide with section 70.
Yes, madam. No, insofar as the merits of the appeal are concerned, my lords, I would not want us to, I would still wish to proceed on the merits of the case, because what has happened, my lord, if I may take you right now to the record of proceedings, I take your lordships firstly to page 5 of your lordship's record of appeal. And at paragraph 3, the appellant says that in around February of 2002, after consulting with the respondent as to how it should proceed in light of the new legislation, application for registration as an insurance sales executive was made by my employer, Malaika, to the respondent on my behalf, as well as an application for registration as an insurer on its own behalf. He was informed by his employers and believed that the applications were made on the advice of the respondent, who were aware at the time of the consultation of the given of advice of Malaika's commercial activities, as well as my own on Malaika's behalf. So this was to answer, my Lord Collins, there was activity at the time of the registration. He says he received no instruction nor advice to cease business as issued by the respondent, nor received by me. And so the respondent, by his conduct, led me to believe that I was duly registered under the Act. Now, my lords, I will move past that because there are certain notices that made certain indications. He says that at paragraph 5, April 26, he received the first notice from the respondent that he was in breach of section 70. He says that the letter also confirmed that he was registered, and we will look at those exhibits below because they are important to the appellant's case. At paragraph 6, he says it's a condition for registration in the Act that the respondent is satisfied that he's fit and proper for performing functions. And since the respondent always knew of the business I was carrying out on behalf of my employer before, during, and after my application to be registered, and that it was not unlawful to carry out such business prior to the new regulatory requirements. And I believe, my Lord Collins, that is where I was drawing from the material that says that that was the circumstance at foot. Prior to the new regulatory requirements being passed, his confirmation of my registration ought to mean it cannot now use these same actions to threaten me. He says at no time was he given an opportunity by the respondent to attend a fair hearing by the independent and impartial tribunal. My lords, I will go past the affidavit now and take you to the actual documentation, my lord, because it is important. At page 13 of your lordship's record of proceedings is the first notice from the respondent. And it starts, my lord.
I'm sorry, page?
Page 13, my lord. It says the Financial Services Commission has obtained evidence to indicate that you breached Section 71 of the Insurance Act. And there's no dispute as to what Section 71 and 2 says. However, Section 21 of the FSC Act authorizes the Commission to offer you the opportunity to discharge any liability to conviction of this offence by payment of a fixed penalty as set out in the 4th schedule. Very importantly, my lord, next paragraph, resulting from discussions with Malika, the Commission has decided to offer you. So they have had a hearing. This is what Mr. Justice McIntosh identified as the hearing that the company had. Has decided to offer you an option under Section 21 of the FSC Act in lieu of recommending prosecution for your breach of the Act, and if accepted by you, will not commence proceedings to suspend and or revoke your registration. That was the second area of uncertainty in the mind of the appellant, because he was waiting for 2 years to this date, because sometime in July of 2002, the company had applied for registration for itself and its representatives. And so the executive director of the FSC is now saying, we will, and if not explained, we will not commence proceedings to suspend and or revoke your registration. This was picked up in the full court by Mr. Justice Reed, who said that it introduced confusion into the matter. So he took it as a misstatement by the director of the FSC.
But surely it's clearly a pro forma letter.
It has appeared on every occasion that the FSC has written, even to the company.
But the statement in the first paragraph is reasonably unambiguous,
yes,
that you're carrying on insurance business without being registered.
Yes.
I mean, he couldn't have been in any doubt, could he, that he wasn't registered?
The only way it could be interpreted as another interpretation is that if he was about to be or had been registered, he would have had to account for the period of time between filing and the actual grant of registration, the unregistered portion.
Yes.
So one would still not know, because the control for issuance of registration is in the hands of the Commission.
It seems to me that if one of the judges noticed this first,
yes,
the appellant can hardly have been confused about it.
Well, to the extent, my lords, that it is what it is. It was raised in judicial review, and especially, my lord, if you are waiting for your registration for 2 years, having been previously registered to 2 entities, having had fit and proper on 2 separate occasions, and you are to understand that it is in train or it is on its way. Perhaps when he saw that, it must have created a confusion in his mind. My lords, I take you over leave to page 14. And the two alternatives are put to the appellant. In lieu of prosecution for violation of section 70, you are offered the opportunity to pay a fixed penalty under section 21 of the Act. And it speaks about the $100,000. Very interestingly, whilst not a requirement of the Commission, it is understood and accepted by the Commission that Malika will indemnify you if you agree to pay it. So this is after discussions with the insurance company, and I will take your lordships to the actual correspondence between the respondent and the insurance company. They were disposing of this matter on behalf of the appellant to face a criminal charge with the regulatory authority. Upon acceptance of this authority, you will be discharged from any liability for prosecution. So it is not that there won't be determination that you broke the law, but you will be relieved of prosecution. That's what Alternative 1 says, in accordance with provisions of the Act. And Alternative 2, if you reject the fixed penalty, your case will be referred to the Office of the DPP for prosecution. The Court of Appeal, the full court as well as the Court of Appeal, took this to mean that this was an option open to the appellant to take up, and that there would be no determination. He could always go forward to meet his prosecution and answer it there. What the court did not focus on was the term additionally. So this is a separate, what I call regulatory prosecution now. Additionally, the Commission will commence proceedings for the suspension and or revocation of your registration. This is will commence proceedings for the suspension and or revocation of the registration.
The irony of all this is that if your side had looked into the relevant provisions of the law, they would have discovered that this was a wholly bad notice. Yes. Because, or at least, you could simply sit back and take no notice of the notice, because if you're then prosecuted, there'd be no possibility of the prosecution succeeded, would there? Because the notice refers to section 1 of this, 21 of the Financial Services Commission Act, which applies to an offence under any relevant act being an offence specified in the 4th schedule. Now, the 4th schedule hadn't yet come into force, and indeed it didn't come into force on any basis until 2005. And none of these offences all relate to the period before 2004. So if you just sit back and do nothing, you would just wait to be prosecuted and then point the relevant provisions out, and be no possibility whatever of your being convicted. Whether the Validation Act would have that effect, what effect the Validation Act would have, I don't know.
Well, all the Validation Act does is to excuse the Commission
yes,
from its defaults. It doesn't create a criminal liability which didn't exist at the time.
No, that was our reading of it.
You see, looking at another way, if we go to section 70 of the Insurance Act, make sure I understand this correctly, which I think is on page 75 of the Act itself. Section 72, any person who contravenes this section should be guilty of an offence. And the offence is carrying on or purporting to carry on business without being registered. But, as at the time we're talking about, leaving aside the retrospective legislation, that there's no way he could be registered, is that right?
He couldn't have.
Because he has to be registered to, he has to apply to the Commission. That's the Financial Services Commission. But the Financial Services Commission has no power to deal in insurance matters, which presumably includes registering. So, as my Lord Collins has said, what offence has he committed? Because his answer to a prosecution is, well, there is no statutory means for me to be registered. And so how can I commit an offence by failing to register if I can't register under the law?
That would be the legal position, but insofar as the factual position, he did in fact do all he thought he could do.
Yeah. Well, but that's beside the point, because he did all he could have done, but he must have known that the registration process is not completed until there's a certificate of registration. putting the papers in is not sufficient.
Well, my lord, the difficulty with that is that at the part, when I took your lordships to his affidavit, he says he was under the guidance and direction of his company, who was, to his information, under the guidance and direction of the respondent.
Well, that might be a mitigating factor, but the legislation is clear.
It gets into the question of strict liability. Because if you have done all that you can do and you believe yourself to be operating within the ambit of the law.
It's nothing to do with strict liability.
Well, it's so far, my lord, as the fact that it's a brand new company and there's no way until the FSC actually register the company, you yourself can't get a registration. Which is why on the question of judicial review, when they came to that arrangement with the FSC to withdraw their application, the tide went out and left all the representatives in a position where they would be afoul of the law. So that was another area of complaint, because if your lordships look on to I'll take you straight to the letters that were exchanged between the FSC and the company, found at page 25. And this is obviously without prejudice to the legal position in the first place, which your lordships have identified. It starts, Malaika has breached Section 7 of the Insurance Act when the company continued to carry on insurance business in Jamaica, whilst this application is before the Commission. And you'd appreciate, my lords, that it is the Commission that has 100% control over the registration. So they did not issue them with a registration, even though they had applied, and therefore not registered to do so. Under the Act, it is offence. Additionally, Malaika employed a total of 22 sales representatives who sold 329 policies, totaling $1.9 million annually in premiums for the company. These sales representatives were not registered by the FSC to sell insurance, and they couldn't be either, my lord. That second observation is gratuitous in the sense that you would have to have been registered first as a company for them to be registered.
Well, forgive me, but I'm not quite sure I follow very much of this. Unless the retrospective statute enabled it to be said that an offence, which wasn't an offence at the time it was committed, is to be treated as though it were, why is your client worried? Because he simply says, I'm not paying any penalty, prosecute me. And when he's prosecuted, he says, but I haven't committed any offence. And the only answer to that would be to read the retrospective statute as though it created an offence backwards in time, which might be quite difficult to read off the words of the statute.
But this is
that's really my question. Why are you bothering?
This was the position in the Court of Appeal as a preliminary point, my lord, and ruled in favour of the respondent that it had that effect. And that is why that was the limine point. That was the first judgment of the Court of Appeal in this case, and then they went on to deal with the substantive merits.
But they only held that the Act validated the penalty notice, didn't they? They didn't say that it. They didn't say anything about what would happen at a future prosecution. As far as I can see, the only possible answer to the way my lord puts it in paragraph in relation to section 71 is that if you just read the words of the statute, it says that no person shall carry on or purport to carry on business as an insurance intermediary unless he's registered. Your client was not registered, he therefore committed the offence, and the fact that he couldn't have become registered is neither here nor there. I mean, that would have to be the argument for the prosecution at any future prosecution. Whether they would have the effrontery to advance it may be another question.
I ought to know the answer to this, but where is the statutory provision about penalty notices?
It's in schedule. I think it's in section 21, isn't it?
It's at tab 2, my lord.
Yes, which section?
It's marked.
No, it's section.
It's section 20, it is section 21, isn't it?
It's section 21 on page 15 of the Financial Services Commission Act, which applies to an offence specified in the 4th schedule. which of course was the schedule, which didn't come into force until 2005.
I see. So they had reason to believe that he'd committed an offence. So given the Validation Act, you're not in a position to argue then that that the penalty notice was bad because of the flaw in the coming into force?
Well, we took the position, my lord, that at the full court, and this would be at a time prior to the Validation Act, this would have been an end of the matter in the favour of the appellant.
Yes, because although as a result of the Validation Act, the act of giving the notice was validated, and they believed that the appellant had committed an offence, still, it couldn't be a good notice to discharge a liability to conviction because there was no liability to conviction.
All of which was raised at that time, not quite in that way, but at the Court of Appeal, once the absence of authority came to the attention of the appellant, they argued that there was no force and in fact there was no authority at the time. My position before your lordship's board is that once it came to the attention of the full court, and as the full court acted in error, the full court, when they were sitting in a matter where the respondent had no legal force. And the fact that they cured it after the hearing of the full court, I think, is significant, because when the Court of Appeal addresses it, it ought not to have cured them as far as a challenge was concerned. Because if it had come up in the full court, if somebody had walked in, as Lord Collins had pointed out, walked in with the gap, walked in with to demonstrate the absence of authority, the full court would have had no alternative but to have granted a judicial review in favour of the appellant.
Why is that?
No, I'm saying, my lord, this is argument, my lord. I'm saying that at the time of the hearing in April of 2005,
before the Validation Act, in other words.
Before the Validation Act, it's only because it was not brought to the attention of the court while the court went on to hear a judicial review and to treat the respondent as having the authority to be a respondent in the judicial review and to act as they had and to rule in their favour. And when it came to the Court of Appeal's attention in 2006, we're saying that they ought to have said that what took place in 2005 before the full court ought not to have been. Rather than keep it alive in favour of the respondent had to continue with his appeal and then ruled against him again. That is the effect of not treating correctly with the Validation Act. Because that was the state of law in 2005, my Lord Collins.
Are you saying the Court of Appeal under the Jamaican procedural rules had no power on the appeal from the full court to rule that as of now,
yes,
the retrospective legislation applies? It's still the same judicial review process which is taken to appeal. Are you saying the full court the Court of Appeal had no power to rule on the material before it, which showed that the 2001 Act had been retrospectively validated with respect to insurance business, but it had no power to hold that cured the situation?
It should have had no power because it would have made a determination, my Lord.
But normally the Court of Appeal will rule on the position as is at the time of the appeal.
Except for one thing, my Lord, it would have been by mistake that the judicial review went as far as it did in the first place.
Well, certainly, but the Court of Appeal was there to sort things out. At that stage, it had been validated.
Yes, and in fact, this is why there were challenges as to costs, etc.
Yeah, I can see that.
Yes.
I can see that.
Because of every aspect of it, my Lord. And this is without even addressing the merits, because the validation was a boon to the appellant. at that stage.
May I ask you one further question?
Certainly, my lord.
In this jurisdiction, not sitting in the Supreme Court of Jamaica, but in England and Wales, we're governed by the Human Rights Act and the European Convention of Human Rights, which outlaws retrospective legislation creating criminal offences which weren't criminal at the time that they were committed. Is there a similar provision
I believe
either in
we are
Jamaican law or in the
signatories.
Constitution of Jamaica?
I believe we're signatories to the Organization of American States, which deals with the human rights aspects. And I believe it comes to your lordship's board, the matters of murders, etc., before in Jamaica. But after we go past the Judicial Committee of the Privy Council, and I know my learned friend from his previous life would be able to speak more fluently on this, we have to observe the human rights aspects.
But which human rights? In the Jamaican Constitution? We're not governed by the European Convention.
No,
of
we're
Human
not.
Rights.
No, we're not.
You may be governed by the International Covenant.
I would only imagine that they have corresponding provisions, my lord, somewhat similar to the European conventions, the ones that we are signatories to in the Organization of American States.
The Inter-American.
Yes, the Inter-American, yes, my lord. Because what it does do is it offends his rights, his constitutional rights, because he would have not been guilty of a criminal offense at the time before the full court, and then brought to life by the Validation Act after he challenged. And we see that there's significance, my lord, in his challenge, because he challenged before they cured it. Had he not filed his application for judicial review, then perhaps I formed the view that there might be argument that the Validation Act might see.
But do the respondents rely upon the Validation Act as entitling them to prosecute your client for these offences alleged offences in 2004? That's unclear to me.
I would have to speculate that would be their position, because they stand by.
Well, we'll ask them when it comes to that.
Perhaps no, because they stand by their notices of April 26th and July 1. They stand by.
Well, they may stand by their notices on the basis that said that they had reasonable grounds to think this and that. But that's a different point from saying what they will do if they win.
Well, my lord, that is the sword of Damocles that has hung over this appellant from the day he got the first notice. And it is most ironic that the Validated Act actually introduces another legal hurdle, because you have to have acted in good faith for your acts to be validated. So if you had the force of law at the start, the good faith is only implied when you act as a public authority. But under the Validation Act, and it says so, my lords, if you look at the first page of the, where's the validation? Tab what? 3. Tab 3, my lord. Overleaf at page, at the second page of it, my lord. And whereas acting in good faith, the Financial Services Commissioner's officers are first employed in the administration of the Financial Services Commission purported to exercise authority over assurance industry in the absence of a notice to bring into operation, etc. And also the next one, and whereas it is desirable to validate and confirm all acts done in good faith. So there would have had to have been an additional judicial test as to whether they met good faith in their actions. And this is why how they conducted themselves in relation to the employer of the appellant becomes significant. Because they entered into discussions with the appellant, and I was taking you to that page 25, my lord. And you will see why we say there is a certain question.
But are you accusing them of bad faith?
My lords,
You haven't accused them of bad faith so far, have you?
not yet. My lords,
So we're proceeding here on the footing that you accept that they acted in good faith, or at any rate haven't asserted that they're acting in bad faith.
I was taken there from page 25. I was about to read page 25, and then it's a matter for your lordships as to whether or not they acted in good or bad faith.
But you haven't anywhere ever suggested, have you, that they acted in bad faith? Have you? There's nowhere in any of this materials contains a clear allegation of bad faith, is there? Clear or any allegation of bad faith?
The appellant, you can look at the appellant's affidavits, my lord,
Look at page 16.
that he, look at paragraph 15 of page 9, my lord. starting actually overleaf, my lord, at paragraph 13, page 8, that I've recently discovered, because this was outside of his knowledge according to his affidavit, that the respondent had been in continuous dialogue with Malaika, which said dialogue did not include me, with a view to arriving at a negotiated solution to the respondent's dilemma as a result of its perception of the effect of the FSC Act and of the tacit permission to Malaika to continue the business without being formally registered. Insofar as I'm now aware, an agreement was reached between the respondent and Malaika, which allowed Malaika to successfully reapply for registration after May 1, 2004, so long as the operations of Malaika ceased in the interim about 6 months. And Malaika agreed to this adverse process being undertaken against its sale representative, including me. My lord, the letter from the attorneys at law for the appellant found at page 16 is absolutely very terse, very terse. At paragraph 3, we note that you have decided to invoke the provisions of Section 21 of the Financial Services Commission Act without ever having given our client an opportunity of attending a fair hearing by an independent and impartial tribunal of the evidence that you say you have. Not one particular of any charges ever been presented, etc. That's another matter. Going on to the next paragraph. Based on our instructions, your letter is the product of a negotiated arrangement between yourselves and his former employer, Money, to whom you have unethically copied the letter, which will enable Money to regularize its own situation, obtain a license from you, save your organization from embarrassment, and make its former agents, including a client, the scapegoats for your own dereliction of your public duties. So, my lords, I wouldn't want to put it in my mouth that they have to come back to it. I'd let the material speak for itself. My lords, going back to page 25 of the record of proceedings. Are you hearing me clearly, my lords? Okay, thank you very much. Thank you. In light of and this is paragraph 3, in light of its anticipated adoption of a policy to address companies operating illegally in Jamaica that seek to regularize their operations in an effort to balance the policy objectives with the spirit of the law, the Commission has decided to offer certain conditions to Malaika in lieu of recommended prosecution of the company, and its sales representatives and imposing regulatory sanctions, arising out of a meeting with you, acting on your client's behalf. So this is Mr. C. Dennis Morrison, Peace Counsel, now Justice of Appeal in Jamaica, but as he then was. There was a meeting with the attorneys acting on your client's behalf. The Commission will hereby formalize the conditions under which it will forego referring these breaches for prosecution. At our meeting, the Commission offered the following conditions. Overleaf, 1. Malaika will withdraw its application submitted to the Commission in February 2002. The application, while submitted in February, is not deemed complete for processing until August 2002 when all the required documents were received, and it goes on. Malaika, number 2, will not submit another application for registration under Section 10. This represents a minimum period of 6 weeks after Malaika terminates its operation, which were in breach. 3, Malaika will establish the offshore customer service center. 4, Malaika will offer a refund full premiums to all policyholders and make such refunds to those policyholders who make a request for refund. 5, the 22 sales representatives will be offered the opportunity to pay a fixed penalty under the 4th schedule of the Financial Services Commission Act in lieu of prosecution for violation of Section 70, and B, revocation and or suspension of their registration. It keeps returning, my lords, the question of whether they were registered or not. Whilst not a requirement of the Commission, it is understood and accepted by the Commission that Malaika will indemnify those sales representatives who accept the fixed penalty alternative to prosecution.
What I can't quite understand about all this is what the underlying basis of this debate is. I mean, the company were paying for this. So is the company financing this litigation on your side?
No.
It isn't?
No.
Or they would have paid the 100,000?
They were prepared to pay the 100,000. My Lord, you've hit on a crux of the matter. This was a means to solve a problem. And what they would do, the company would withdraw, so there'd be no blot on the company's record. The sales representatives would be the ones that would go forward to meet this fixed penalty. It would be their names that would be associated with the transgression, not the company. The company would then meet the expense, so they would not be out of pocket. But those who felt that their name was more important, those who had been in the industry for several years, those who had been previously registered under the old regime twice, met fit and proper before, those who thought they had done all that they could do, which was to file, their company had filed, they had filed for registration. 2 years had elapsed.
Well, why not just refuse to pay the penalty and defend the proceeding?
Well, that's what he did. His lawyer's letter said...
No, they didn't. He took these judicial review proceedings. Why not just wait to be prosecuted and then be acquitted?
My Lord, if he felt that it was a wrongful act in the first place, not to mention, as it transpired, the irony of it, as you said, that it was not even an effective notice and not an effective commission as regards the insurance industry. Had he had what his complaint was, my Lord, was that he was not afforded the opportunity to have that meeting. Had he had that meeting, if he was offered the opportunity to withdraw his application without consequence, that might have been a resolution as well.
Mr. Dunkley,
My Lord.
under the old Act, he'd worked for the first company, which was registered under, or whatever it was, certainly performing legally under the old Act, and then he was registered under the cover of the umbrella. He then moved to the second company, it was registered, he was registered. He then moved to the new company, MLICA, which wasn't registered, it was performing illegally under the old Act, so he wasn't registered under the old Act. When the new Act came in, he wasn't registered, he'd never been registered under the old Act when working for that company. When the matter came to the attention of the Commission, they wanted to perform due diligence, which took a very long time to decide whether the new company, which had been acting illegally under the old Act, was a fit and proper person. Where did he get the idea that working for a company which wasn't registered, so he wasn't registered, he was entitled to write insurance business?
He got the idea, my Lord, from the company who he says got it from the respondent. It's in his affidavit, my Lord. The very first place I took your lordships to, which was paragraph 3 of his first affidavit.
It was because they were a foreign company, they believed that they didn't have to register, isn't that right?
They believed that they didn't have to register under the old regime, and as I understand it, they brought the new act into force now to
Yes, right. But in the period before the change in the regulations, he and Malika believed that it wasn't necessary to be registered because they were a foreign company. But in that belief, they were wrong. Yes?
But in that regard, he considered Miller and asked the FSC to explain their delay. That is what the judicial review was about, to give some explanation as to the 2 years, what was happening, because it was for their certain knowledge. Because the contract of employment, Miller, in the affidavit of Miss Holness, indicated that they were aware that the appellant was employed to money. In 2002, they submitted contracts of employment. So for 2 years, unless they thought, the FSC thought, and this goes back to reasonableness, unless they thought that they were on the payroll of money for 2 years without writing any business. And then most importantly, my Lord, when the lawyers exchanged correspondence with the FSC, it is very interesting to note that the only refund that they were asking for was the refund of business after they filed. And I took that to mean, and that is to be found, my Lord, over at page 28.
28.
As you were, my Lords.
Did you say 20?
31.
Did you say 28?
31.
31.
Yes.
Thank you.
There was an interesting sequence of letters, but this was the last of them, my Lords. I hope I don't have to go backwards to take. This was the FSC responding to a rather sharp letter from the lawyers for money. And in fact, my lords, to give you some context, my lord, perhaps I really should go to page 28 so that we can appreciate what page 30 said. At page 28, this is the response to that letter. And again, bearing in mind that the complaint of the appellant was that he did not have a hearing. Here is Mrs. Morgan writing on February the 18th in response to the letter I just took you to. It says, refer to yours, dated February 13th, to Mr. Dennis Morrison, and with reference to that, to the meeting we had on February 11th, and these meetings predate the notice, the two notices that were delivered to the appellant. We note that yours does not document the fact that it was proposed by the FSC at that meeting that the FSC would treat with priority a new application for registration made by money after May the 1st. FSC will use its best efforts to make a decision to approve or reject within 90 days. 2, money will not be required to file as elaborate an application as the one submitted in February 2002, but may submit an updated application. 3, FSC will spearhead the issue of Bank of Jamaica as regards your approval. The deposit of $3.2 million deposited by money will be immediately released from trust in favor of the FSC on the withdrawal of the present application. And 5, as it relates to the offer for refund made to policyholders. That offer relates to policies issued after February 2002. So business that was written before 2002, the FSC was not asking for a refund. That's a very interesting feature. Is it that they were therefore considered to have not been in breach of the law until they actually applied to come under the law?
Well, that's impossible because carrying on business in Jamaica on insurance is defined extraordinarily widely in section, I think the pages have got out of order.
2001 Act, my lord?
It's
2001, my lord?
in 2001 Act, page 11
This is the new Act.
Page 11 of the Act, yes, and page 11 and 22 of the Act.
And we were speaking about under the old Act before. What page? So, my lords, and there was concurrence with that position by the FSC overleaf at page 30. So he responds to Mrs. Morris at page 30, and he...
The letter at page 28, is that written on behalf of whom? Money, is it?
Yes, on behalf of the company, referring again to the meeting of February. And overleaf at page 30. The paragraph 2, with respect to application registration, advisor set a target of 90 days. Although FSC tends to strive to meet the target, you can appreciate it has to rely on outside agencies, the supervisory authority in the incorporating jurisdiction, which may shed some light as to why money wanted to withdraw its application rather than face any fixed penalty. It will have consequences. And it will have consequences for any serious insurance executive who may choose to practice outside of Jamaica. And that was one of the complaints that's found at page 35, when they complained that if we went to write business in Canada or in Miami, we will have a difficulty being registered, because as your lordships know, under the new interlocking regulatory framework of the world, once they're going to ask, were you ever convicted? They no longer ask that. Were you ever charged? Were you ever investigated? Were you ever? This was an expeditious solution to answer my Lord Collis. However,
well, just to take up that theme briefly again, was a prosecution ever launched? No.
not that we're aware of.
Well, I dare say you would be aware if they launched a prosecution against you. Because in this jurisdiction, there is jurisprudence to the effect that where it is possible to assert your exemption from criminal liability in a forum better suited for that, namely the criminal court, that is a reason that judicial review should not deny. Is there any similar jurisprudence in Jamaica?
My Lord, I have actually done quite a bit of judicial review, and there is a sort of uneasy relationship between the two. And I believe that in this particular case, because I asked that of my instructing attorneys, there may have been some forbearance, because I know to my certain knowledge there was no stay. But perhaps in light of the impending appeals, it may have been perhaps ill-advised.
But in any event, the point was never taken against you
No.
in the judicial review application. Yeah, thank you.
Just help me on this, if you would.
Yes, my lord.
Subject to one point, assuming that you win
Yes, my lord.
this appeal, is there anything that would prevent your client being prosecuted?
My lord, that question was asked of my instructing attorneys yesterday. The answer to which is that subject to the issues of the Validation Act, etc., subject to those, there would really be no impediment to their bringing a prosecution. However, this particular suit, and I was at pains to check on that this particular suit number HCV 1741 of 2004, the corresponding appeal, and this appeal to His Lordship's board would end. If they chose to proceed after that, would really be a matter for them. But these proceedings would really come to an end.
Well, I see from your original application that you not only want a certiorari to quash the decision to offer a penalty, you also seek an order of prohibition to prevent the Commission from laying a complaint to the DPP. On what basis do you say that the Commission should be prohibited from saying to the DPP, look, we think that the appellant has committed a criminal offence, you must now make up your mind whether to prosecute or not? How can you, on what basis do you say that you can prohibit the Commission from reporting the matter to the DPP?
Having had the benefit or the burden, my lord, of coming in before your lordship's board and not before, as I indicated to your lordship's answer, to your lordship's question a moment ago, on the prohibition aspect, I had answered your lordship in the affirmative that there would be no impediment. So I was not concentrating on the prohibition aspect of the relief. I was concentrating on the certiorari aspect.
Do I understand you to be saying that you don't have any basis for prohibiting the Commission from reporting the matter to the DPP?
Afresh, my lord. It would be afresh. It would be afresh. It would be it would not be pursuant to what has transpired before the court below and your lordship's board. It would be afresh. It would be afresh, my lord.
Sorry, I didn't follow. What do you mean by afresh?
I hold of you, my lords, that in relation to the ability to, they would have had to have, now that they've been validated, my lord, they would have been challenged in relation to their first acts. But if it is that they determine, unless limitations is considered, unless limitations is considered, they would have to look back now and say, we consider that the period of time that you acted without being registered, irrespective of our notice, they'd have to issue a fresh notice, my lord. They would not be able to.
They don't need a notice, do they?
Say again, my lord?
They don't need a notice. This assumes you win this application, and the notice is quashed.
That's what I'm saying, my lord. They would have had to have issued a fresh notice in 2009.
They don't need a notice. All they need to. Yeah.
Why? I mean, they don't have to.
No,
they don't have to offer you a penalty.
That would have been presuming that they went down the same road again, my lord. Yes.
Surely they could just write you a letter saying we're reporting your conduct to the DPP. They don't have to offer you a penalty.
No,
and they can do that, moreover, whether you win or lose here.
Well, that was my reasoning,
as far as
whether we won or whether we lost. But that's why I called it a fresh, my lord Collins, because they would have to start back in 2000.
So the position is that you're not asking for a prohibition now, is this right? And you concede, therefore, that they could start criminal proceedings against you, and is that so, isn't it, whether you win or lose here?
Yes, whether we win or lose here. I crave your lordship's indulgence. I take some instructions. No, I understand that.
Isn't that right? It's quite. Yes, absolutely. That seems to be the position. Well, they will flush out the respondents as whether they intend to do that.
He's asking that question. I'm dealing with the provision. I'm just saying.
To whether they prosecute or not. All the respondent can do is to state.
Are there any limitation provisions in Jamaica relating to the bringing of summary proceedings?
I'm not.
But yeah, they'll be stuck with 6 months.
We're not aware of any limitation. But they also elect to abandon that too. They may very well have completed their due diligence on the appellant. We don't hear anything more about the employer, but it may be that if he goes on to another insurance company and if he makes an application, he may very well be favorably considered, because the only transgression that has occurred has resulted from these proceedings and the inordinate delay in the registration of money and consequently his own registration. So insofar as his other requirements is fit and proper, all the things that they did not sign on to a fixed penalty in the first place would hopefully inure to his benefit. So insofar as anticipated prosecution, it has never really arisen.
My question was, can criminal proceedings, summary proceedings, they are summary by Section 72, be instituted in 2009 for offences committed between 2002 and 2004?
Maybe consider notice by the DPP. If they refer to the DPP may well consider that the circumstances arising are otious.
There's no statutory limitation.
Not that we are familiar.
The DPP might think it would be an abuse of process in circumstances where the prosecution would have to rely on Section 70 of the Act, and in circumstances where it wouldn't have been possible to be, the allegation would be you carried on insurance business without being registered, in circumstances where it was impossible to be registered because owing to the hopelessness of the government, they'd failed to bring in the relevant provisions. Now, I can see you could say, well, your client nevertheless committed the offence, but to bring those proceedings N years after the event in such unprepossessing circumstances might be regarded as less than satisfactory.
And a breach of his human rights.
And possibly a breach of his human rights. Well, certainly would be a breach of his human rights if they were relying upon the validation provisions in the validation statute. But it's difficult to see which of the validation provisions would help them, as my Lord Collins pointed out some time ago. So these proceedings are really about costs, as far as I can see.
Well, ultimately, my Lord, that is why costs have been the focal point once we finished our presentation. But it was very important to advance before your Lordship's board certainly the good faith of the appellant. It was imperative, and he has brought himself before your Lordship's board in person as well, because it is all about his name. It is all about his honor. And to be asked to participate in an arrangement, I won't be so unkind as to say a scheme, but as an arrangement. And in fact,
well, why didn't he just write back rejecting it on all the grounds of the merits grounds that you've advanced?
Well, he wrote.
Why didn't he just write back saying you're utterly mistaken and everything I did entirely in good faith. You knew perfectly well I was carrying on business.
That's what the letter from his lawyer said, the letters from Palmer and Walters found that page.
Well, that's page 16, yes, where he appears to be saying, right, send it off to the court.
Well, this might be a very unfortunate way of expressing it, my lords, but it was a rejection outright of the suggestion that he should go the way. Now, as to how his advice of the day took him, and to suggest that perhaps we'll have somebody else review this. This is what judicial, as your lordships know so fully, this is what judicial review is about. And in fact, in consulting the various legal texts on the
judicial review is about whether the notice is lawful, whereas his defence is, I'm not guilty of any offence, which is an entirely different point.
His position, but the position in law, because it really is a challenge for law as a matter of law. And once you get to judicial review, you are challenging law. This is just an immediate response to the commission who sent the notice that they did. saying that we arranged for you to cop a plea. So, my lords, I wanted to take your lordships, if you would permit me, through the findings of the full court. Now, my lords, the full court's deliberations really should not trouble your lordships, except to say that one of the judges, my lords, had hit upon what was actually taking place between the parties, my lord. If your lordships turn to page 86, that would be where you would find the judgment of the full court. This is yours. And the three judges, my lords, all came to their own separate conclusions. At page 90, my lord Reed indicates, page 90, my lord, any fair hearing could only arise after the intimation of a breach and before the actual imposition of a penalty. In this instance, no penalty was imposed, save and except that an offer was made on which the payment of a penalty depended on an option of acceptance or rejection. We say it went a lot further than that, and I took your lordships to the material where the executive director indicated additionally. So after we send it to the DPP, we're not going to wait for the outcome of a ruling or the outcome of prosecution, i.e. if you are convicted, we will act in a certain way. He said, additionally, we will institute our own proceedings. So there was, in fact, a determination by the FSC, we say. It was not merely if you elected not to take up alternate one, that it would go through the court system. You would also be subject to the FSC's own internal prosecution.
Well, it says additionally, the Commission will commence proceedings for the suspension and or revocation of your registration. But he's not registered.
That's meaningless.
Well, this is why on judicial review, that would have to have been a question asked of the authority. Why did you write this? Why did you write this way? That is something that should have been put to them on judicial review.
It was simply a hopelessly uninformed letter.
Thank you, my lord. By the persons who purport to regulate you.
Well, I think one could hazard a reply to the rhetorical question, namely that it is a pro forma letter and they omitted to delete the relevant portion.
My lord, it also appeared in the letter of February to the company.
Yes.
It also appeared in the letter of July 1 thereafter. On each occasion, in very specifically drafted letters, they weren't boilerplate, my lords. They were specifically drafted letters.
But it was an utterly meaningless incantation because what was undeniable was that your client was not registered. So there's no question, as my Lord Saville points out, there's no question of suspending his licence or his registration because he didn't have it.
I would not wish to stress it beyond this point, my lord. If you are waiting for your registration for 2 years and you see anything that would indicate that you were, this is part of the unfairness and the unfortunate circumstances of the appellant. My lords, overleaf at page 91 at the bottom, this is where my Lord Reed picked it up and says that this matter of the registration only served to import confusion by asserting that the appellant is in fact registered. But in certain jurisdictions, they would take a very strict view that they would hold the commission to that statement. Now, it's not quite contra proper, but when they are the ones that would hold that power and authority, my lord.
Where I don't follow you is your submission, as I understand it,
Yes, my lord.
that it wasn't just an offer for a penalty, it was also telling him, without giving him a chance to say anything about it, that they'd cancel his registration. But I repeat, that's meaningless because he didn't have any registration. So how can you take advantage of that?
No, my lord, I believe I can, because he goes on to say at the same page 14 that your lordship is alluding to, under alternate 2. Additionally, the commission will commence proceedings for the suspension.
Sorry, what are you looking at?
I'm taking you a little bit below that. The circumstances giving rise to your prosecution and facing regulatory sanctions will be taken into consideration in any fit and proper assessment of you by the Commission. So this will be page 14, my Lord. Yes. So, my Lord, my learned junior reminds me that there's a juxtaposition in alternate number 1, where they indicate to you, which is just above, at the center of that paragraph, upon acceptance of this alternative, you will be discharged from any liability for prosecution in accordance with the provisions of the FSC Act. Face no other regulatory sanctions. So, my Lord, they speak about other regulatory sanctions, and that would be quite independent and apart from the prosecution by the DPP or otherwise. No other regulatory sanctions by the Commission. So we say that there exists another element of action that can be taken against the appellant. So he says, upon acceptance, apart from prosecution, and therefore, when you look at what happens in alternate 2, 1, you face the DPP, but 2, you face our other regulatory sanction, and they will look askance at any application for fit and proper, and that would have been ongoing whilst applying for registration, irrespective of whether they issued one or didn't issue one. His fit and proper, an integral ingredient to obtaining registration, would have been under challenge, quite apart from the outcome, because it does not mention that it is reliant upon the outcome before the DPP and the criminal courts. And he had no opportunity to speak to that. My Lords, to conclude the hearing before the full court, my Lords, I take you finally to page 114. And this was an aspect that was not considered by the Court of Appeal at all. I take it to paragraph 2 of page 114. It is clear that Malika acted as agent.
So I'm sorry, can you give me the page again?
Page 114, my Lord.
Thank you. Yes?
Yes, my Lord. It is clear that Malika acted as agent for the claimant in seeking to bring him within the ambit of the Insurance Act. This was done with the full knowledge and consent of the claimant. Now, I do not know if this is quite an accurate statement, but I believe his lordship went this way in order to get to his next paragraph, which is, as agent for the claimant, Malika had a hearing with the FSC before the latter made any contact. So his lordship deemed a relationship of agency between the company for the purpose of importing into his consideration that the appellant had an opportunity for a hearing. And he notes quite correctly, the offer by the FSC came out of these hearings.
But what in effect is said against you on this aspect of the case is that this wasn't telling you to pay a penalty. It was making an offer to you that you could pay a penalty and, in fact, thereby probably escape prosecution. Now, speaking of myself, I find difficulty in seeing why an offer to do something requires all the human and other rights of an individual of whom it is being demanded that he does something.
If I may, my Lord. The correspondence to money showed that money was considered by the FSC to have breached the law. The arrangement that money arrived at with the FSC was that they would withdraw their application. There's no record of them having committed an offense. It is the representative who will be faced with having to admit commission of the offense. Now, we do not know what would have been the outcome of a hearing.
The irony of all this is that it's common ground that your client was carrying on insurance business.
It's also, It's also common ground, my lord, that the company was carrying on business of that nature without being charged.
How much is in US dollars or sterling 100,000 Jamaican dollars?
This would be about just under £1,000, my lord.
I said, how much has your client expended in this, in costs? In this
Quite a bit, my lord.
Approximately?
It would be approaching, if I may, my lord. Perhaps about $2 million, my lord. Jamaican dollars. Which is maybe about, which would be about 10,000, about 10,000 pounds.
That sounds like an underestimate.
Perhaps, yes, perhaps it is an underestimation. It has been costly, my lord, but if your lordships had noted from the newspaper clipping, the complaint, that's the only record that I found before the courts as to why there was this almost, this quest, has to do with the fact that it's a expeditious solution to that problem then that may have led, because you're now admitting. And one of the arguments advanced in the court below, which I certainly didn't advance here about the mens rea, was that he felt he had no intention to break the law, had done everything, and in fact found himself in a circumstance where, because they had this meeting of February that came up with this solution, the company withdraws, so the company saves its name, does not have to face the SEC in America with regards to any breach in Jamaica. Once they withdraw, the reprehensible aspect of it is that once they agree with the FFC to withdraw, it leaves the application of the representatives high and dry, because they cannot get a license without the company being licensed. So it immediately would have put them into breach. If they had come up with another solution, it's really a poorly executed plan going along with a poorly executed notice.
And then you don't pay the notice, defend the proceedings, be acquitted.
Well, my lord,
If you're guilty,
yes.
then that's right. And if you're acquitted, well and good.
But yes.
That's what the solution to an innocent person is to say, dear sirs, I refuse to pay your notice. It's going to be down.
Well, I understand that.
But it's more than that, because the deal offered was you agree to a fixed payment, a very modest one. The company pays, and it won't be a blot on your record.
It won't be a blot in Jamaica, my lord. It won't be a blot in Jamaica.
Why will it be a blot anywhere else?
Because if you're asked, were you ever charged? You would have to answer in the affirmative.
Were you able to say no?
Well, I don't know, my lord, because that's the point.
Be able to say no. The whole point of the notice was that I wouldn't be charged.
My lord, I read it that there's no further action taken against you, but it flows from an admission. It flows from an admission that you have broken the law. It flows from that admission. This is why it was so important to the FSC that you take this route. And it shows what happens if you don't. You go forward and you face all these other things. So they found it to be an expeditious solution to that problem of maybe perhaps the 2 years that they took to register them. But the real point is, my lord, any future administration, any future commissioner could come along and say, I disagree with how this was resolved in 2000.
But if that really is right, then the solution is not to pay notice, let them prosecute you, and be acquitted.
As opposed to judicial review. Well, the judicial review, perhaps in the mind of the appellant, was going to have the same outcome.
Won't have the same outcome, because we agreed earlier that whatever the outcome of these proceedings, they can still prosecute.
Well, my lord, at some point he would face prosecution, but
unless you pay.
Well, pay would be to be making an admission.
I mean, once you accept, as I think you do, to my mind quite correctly, that whatever the outcome of these proceedings, you could, in theory at least, be prosecuted.
In theory, yes.
Then the proceedings seem
but
extraordinary expenditure of money.
It has been, my lord, but suffice it to say that the appellant has felt that it is really a matter of honor. Because when they asked him to accept the liability of the insurance company, even to the extent where the insurance company was going to meet this money, and I would say it was an inconsequential offer on the part of the insurance company because they were going to get back $3.2 million.
Yes, but honour can be asserted in the criminal courts. This case exemplifies the philosophy that underlay the jurisprudence that I referred to earlier, because the criminal courts can deal with it expeditiously at considerably less expense, and they will bring finality. As my Lord Clerk points out, these proceedings, even if successful for the appellant, will not necessarily bring absolute finality.
Well, my lord, insofar as judicial review is concerned, my lord, which is quite separate apart from the actions that they may or may not take going forward, was whether or not their actions were reasonable in how they proceeded. In coming to the arrangement that they did with money, and he had asked for a hearing, perhaps when he wrote the letter, his lawyers wrote the letter that they did. If they had invited the appellant in, notwithstanding the terseness of the letter, if they had invited him in to meet with them, perhaps he too may have been offered this withdrawal of application, which would have also ended the matter as well too, my lord. It wouldn't always be weighted in favor of the actions taken. In fact, even one of the judges made in saying the short answer to whether or not it took them 2 years and there was no explanation coming from respondent. He simply said he saw no evidence where the appellant had asked his employer what was happening. So at each occasion, this appellant has had a burden on him. And even the observations of the Lordship's Board would tend towards retaining the burden on him. He would have to make an election as to whether or not to face prosecution when all he wants to do is sell insurance. It has placed a burden. Judicial review might have, to the advice of the day, been such as to consider that perhaps all the tenets of judicial review, fairness, transparency, which would not obtain in the criminal court, because the criminal court would not be concerned with the process of the Financial Services Commission. The criminal court's remit would be whether or not he breached the Insurance Act, whereas the judicial review would look at whether or not the notice was fair, how they proceeded, they arrived at our arrangement with his company. All of that would be the remit of the judicial review as opposed to a criminal court. So, with respect, my lords, I believe there was some merit in going forward. What has happened, though, my lord, is that he lost before the judicial review. Had he won before the judicial review, his costs would not have been what I have described to you. So losing is what actually brings about the hurt, as opposed to the process. Had he succeeded, he would have been down about 500,000 less and would have been recovering his costs from the other side if he had won. So no court has looked askance on how the FSC did its business. And that is the subject of the judicial review, as to whether or not they did. And I understand that a court does not substitute discretion, but your lordships have seen ample evidence of a lack of transparency, a certain unfortunate, yes, the lack of consideration for the appellant and the consequence of making such an admission. If I take your lordship just very carefully, quickly to the newspaper report that I refer to, which is at page 35. My lords, at paragraph 2, midway down, it says this is a black mark against us. And we cannot get licensed to sell insurance in Canada or Miami. The FSC has ruined our careers. And the FSC's response is we don't blacklist people. But I think they missed the point. Once you have made such an admission, if you go into another jurisdiction which was not party to this understanding or arrangement, you only have the raw data, which is that you were investigated and you made an admission that you broke the law. So you would find yourself having to explain each time that, oh, well, my company paid my bill, etc. You would be on that regime for the rest of your declaratory days. As long as you have to make a declaration, this would be your circumstance. Had he had the hearing, and I'll go further, my lords, I was taking the view, as with Mr. Justice McIntosh, my lords. Mr. McIntosh viewed that they had that hearing. And at that hearing, that is when he was afforded the opportunity to be heard via his company. But the moment that they were going to apportion the sanctions, what would have happened at that stage? They would have had to have brought their meeting of February to a halt, because that would not have been in the interest of the appellant to agree to face the sanction alone, albeit funded by the company. Implied mutual term of trust and confidence between employer and employee would have operated against money, they could not have made such an arrangement with the FSC that would clearly have been to the disadvantage of the appellant and the other agents as far as incurring a criminal sanction. The FSC would have had to have stopped at that moment because they too would have had to consider the fairness insofar as they had already concluded that this is how we'll proceed. And based on those discussions and that conclusion, they then offered it to the appellant. Had they paused, brought in the representatives, got some input from them, there would have been a certain greater degree of fairness to the process. And I believe I have taken your lordships quite thoroughly through the material. So there's no dispute between the parties that this was an arrangement between them. The affidavit of Ms. Holness said they met several times with money. So they met several times with money, but never met once with the appellant.
But it's like in this jurisdiction, we've had plenty of case law which says the police caution, if somebody elects to be cautioned rather than prosecuted, that's not a criminal offence. And what this agent says, which is immediately denied by the Financial Services Commission, he always has the right to be prosecuted. This is just an offer to let him off. And if in some jurisdiction or other there's a provision that what is equivalent to a caution, a fixed penalty, may be a black mark, well, he can go ahead and be prosecuted and show that he's not guilty.
Well, my lord, that would be something that would visit upon him and at that time would be adverse to him. All he was saying, which is why he was asking for a fair hearing, if he had had the opportunity, like the company, to have his application withdrawn, there would be none of this. So it would have been a matter for the court to determine whether or not, especially as they did have a hearing, that is a matter of record and fact.
Every time anybody is offered the option of a fixed penalty rather than be prosecuted, there's got to be a hearing first before the fixed penalty can be imposed. Is that it?
No,
whatever the circumstances.
No. In these particular circumstances, he's saying because they had made that determination already and had only offered him the fixed penalty as opposed to a hearing at which time he may have made representation to withdraw his application and not be faced with the prospect of either one of these two difficult choices. One, to admit, because before you pay the fixed penalty, it's an admission that you have committed the offence.
Where do you get that from?
My lord, I will take your lordships to
the whole thing is dealt with in section 21, isn't it, of the Act?
Yes, it's section 21.
Which expressly provides that no person shall be liable to be convicted of the offence if the fixed penalty is paid.
Yes. So you pay the penalty and you're not liable to conviction.
So there's no conviction against you.
There's
no
no
point of it.
There's no recorded conviction against you, but there's a record that you have paid a fixed penalty. And so to the extent that it represents a transgression, if you go into another jurisdiction...
But it doesn't, because the terms of the statute is simply that there have to be reasonable grounds to suspect, or words to that effect.
Yeah, but my lord, I can only take it as high as to say that money certainly avoided even the prospect of this non-event. Money was prepared to withdraw, and you can only take from the conduct of money or the behavior of money that perhaps it held more terrors than the word suggest, because it is very difficult, it becomes very subjective when there is an assessment as to fit and proper or in terms of a registration. It is a blot. Now, I concede that in Jamaica the arrangement was for them to pay the fixed penalty and move on, but as your lordship saw from the material that I presented, they were looking beyond the immediacy of this solution.
If, instead of doing what they did, the Commission had written you a letter saying, we believe you have been breaking the law and we are referring the papers to the Director of Public Prosecutions, would you have had any complaint?
They may very well have generated a complaint exactly of this nature, not with the...
Yeah, they don't give you an offer to pay a penalty, because they don't have to, because it's a discretionary power under Section 21. Yes, if they wrote you a letter saying, well, we believe you committed an offence, and we're passing the papers to the Director of Public Prosecutions to consider the matter. would you have had any complaint at that stage?
I believe that they would have complained in any event, my lord,
Well, what would be the grounds of your complaint if that is what they'd done?
Their grounds at the time, my lord, was that they felt that they had committed no offence because of the manner in which their registration application was accepted by the respondent, that there was full declaration and that they had put it in. And in fact, in the affidavit of Ms. Holmes, she recognized that in 2002, they put it in, and the contract of employment was part of the documentation filed, and that they then claimed that in 2003 they got this information. It is only 2004.
Well, I can see that you might write back in reply to such a letter saying, I haven't committed any offence at all, and you're wrong to believe that I had. But you couldn't do any more than that, could you? I mean, you couldn't stop them from expressing their belief to the DPP.
My lord, I don't believe we could ever have stopped them from expressing their belief to the DPP.
Yeah.
But they may very well have elected to go to judicial review on the basis that they ought not to be referred to the DPP for the circumstances surrounding the registration of both the employer and the employee. They say that to the certain knowledge of the commission, they had filed. The affidavit of Ms. Holness says in 2002 they did so, they were doing their due diligence and then discovered. They even said they reported their activities. And even the collection of the money, I found, was significant, my lord.
Well, I follow all that, but at the moment, and it's maybe that I'm missing a trick, I can't see how you could possibly have complained if the Commission, instead of offering you a penalty, had simply told you that they were sending the papers to the DPP.
My lord, in the particular circumstance of this case, the fact that the arrangement that was put to the appellant came in the form of the product of the meeting with the company is what perhaps in this particular case generated the response that it did.
Yeah, I follow that, but if what I've said is right, then your complaint, put in a slightly different way, is that they should never have made you an offer.
My lord, it may have that unfortunate appearance, but I believe that it was not a matter of having made them an offer. It was the fact that the offer came out of circumstances where another entity with similar interests but not quite conjoined interests had that opportunity to negotiate their way out of even having to meet a fixed penalty. And that is why the opportunity for the fair hearing and perhaps the opportunity to have their registration application withdrawn without consequence would have been the happiest outcome for the appellant.
Well, yes, I can see if they wrote you a letter saying, well, we're going to send this to the DPP, I can see you writing back and say, please don't do that. Can we not negotiate something? But there's no obligation on them to say, we're happy to have negotiations with you.
My lord, they had
no legal obligation.
What they did do, though, my lord, which is why judicial review was the preferred course, it was very clear that they had several negotiations with the company. And it is on that basis, my lord, because they had several negotiations and they are applying under judicial review with transparency, fairness, the test of the balance between vigilance and restraint. All of the tenets of judicial review come into play. And this appellant would have been so advised that a judicial review court would look very closely at the public authority. We spent quite a bit of time looking at the appellant, but the public authority would have had to answer in judicial review for its actions. And one of those actions would have been, in fact, the most significant one, would have been their dealings with money.
In effect, are you saying that because they had been prepared to negotiate with money and to offer them a rather benevolent outcome, that it was unfair for them not to treat your client similarly?
But thank you, my lord. But instead, to arrive at the fixed penalty or DPP phase of the exercise. That in a nutshell is it, my lord. Because at that stage, and there were quite a few exchanges before there was communication. So I had indicated that these letters that were read to your lordships took place before April. So there was a back and forth between money to settle on the arrangements, including the dressing down of the executive director in terms of the money to be returned and the things that he undertook to do, etc. And the public authority would have had to account at judicial review for that action to justify how they were proceeding in this way before in respect of the appellant. Because judicial review is intended to be fair, and he was left with a feeling that it was grossly unfair. So even though it appeared on the face of it to have been an expeditious resolution, he wouldn't even have to pay any money, he looked beyond it. He would have wanted to have exited stage left, just like money. And they obviously had the discretion so to do because they did it for money. So as far as the principles of judicial review are concerned, those would play out, my lords, as opposed to the principles in a criminal court. Because as I indicated before, the criminal court would not be concerned with the actions of the public authority. And the reason why he would be in breach, my lord, is because the very same public authority that took you 2 years did not issue a registration. So ironically, they had control to make you be in breach of the law. Because had they issued a registration, say 90 days from 2002, he would not have been in breach of the law. They are in control of those circumstances. As they were supposed to be under statute, they are responsible. So with that responsibility comes certain other consequences. Consideration for your applicants. Your applicant should not have to wait 2 years to then be told that you are in breach of the law, to their certain knowledge. They said it came to their attention in 2003, yet they wrote in 2004. So, your lordships, when you look at the totality of the evidence, it cries out for judicial review. Because they would have to answer. Because it was never his intention to break the law. And they are the reason why he would be breaking the law, because if they don't issue it, they would have to have said to him a lot earlier. So he could have himself have self-imposed if they had indicated, you are not registered. You need to, perhaps he should have gotten a cease and desist, my lord. There are several tools in the arsenal of the respondent that could have taken him out. And it appears from the reading that they had actually intended for them to go forward with registration. They needed to get this bit of housekeeping out of the way. So it was really to solve a problem that the FSC found itself in, having not registered them for 2 years, and then ready to register them, only to find that you have to account for the period of time between their application and which became gross, because at that stage it was 2 years.
During that 2 years, as I understand it, your client was writing insurance, is that right?
That's not in dispute, no, my lord.
So that his expectation would be, or you say it was, that he would be registered.
Yes, my lord.
Retrospectively?
My lord, I can't imagine that it would be retrospective unless the commission took that decision. I do not know if they have the power to give a retrospective, but they can treat, and there are many administrative procedures, my lord, that treat your registration as being from the time of filing. So it may not have had a retrospective effect. They would have granted it from the time of filing, should have taken it back.
And if that's right, there is going to be a stage when he is leaving aside the defects in the Act.
Yes, my lord.
There is going to be a stage when he is writing insurance, he's not registered, and he never will be registered for that time.
That unhappy circumstance would be in the hands of the respondent, because it is they who have the application
But what answer would he have then for saying, leave aside the defect in the Act?
Yes, my lord.
Would he have any answer to somebody saying, but you're breaching the Act? Okay, you expect registration, but until you get it, you can't write insurance.
I will say, my lord, it depends on who's asking. And the reason why I say this is because the very entity who would be asking, and who did ask in 2004, is the very entity to whom he had applied. So he could very well have retorted, you have taken, which is what one of his complaints was, you have taken 2 years. So it depends on who's asking. So at the judicial review, the court could have, which is why Mr. Justice Reed, and I pointed it out, said that there was no explanation as to why. And he said the short answer to that, without calling on the respondent to account for why it took 2 years, and why they, in a sense, did nothing, leading the appellant to believe that he would ultimately have been registered and perhaps treated from the time of his application. His answer was that the burden was on the appellant to find out from his employer what was happening. There seems to have been no inquiry of the respondent. The respondent has to answer. That's what judicial review is about, is the answering of the respondent to these things, because it placed the appellant into these circumstances. Now, had he heard from them within 90 days to say, this is taking longer than we expect, and to give him the necessary cautions, and his contract of employment, as I indicated, by the wholeness affidavit, was known to the FSC. It was part of the filed documents. That's why he had argued, and I understood that argument of legitimate expectation.
Well, again, it's no doubt my fault, but
Yes, my lord.
your client thinks, well, I'm going to be registered, there's going to be no problem with that, the commission is taking far too long, but I'm going to be registered. Therefore, I can now write insurance, and there's a non sequitur in that, because therefore he can't write insurance because he's not registered. He may expect that he will be registered in the future, but in the present, he is not registered. He knows he's not registered. He expects he will be registered sometime in the future, but meanwhile, he's writing insurance without being registered.
My answer is this, my lord. He doesn't write it in a vacuum. It was his understanding that his application, covered by the umbrella application of his employer, is what is before the FSC. So he's writing the employer's business, and this is why the inquiry and the review of the documents would be so important, because, as your lordship will note, how the employer managed to get out of that circumstance was to arrange with the FSC to withdraw, to have a fast-tracked reapplication, to have the premium income remitted back to the policyholders, save and accept for business written before they filed. That's how they attended to it. So he was not on a frolic of his own, my lord. He was not on a frolic.
His remedy was mandamus, really, wasn't it, against the commission to get on with it, or to write to them saying, please give me an interim registration pending the decision.
Yes, my lord, I couldn't disagree that in hindsight. That
not
perhaps,
in hindsight.
No, in the sense, my lord, because we are not here about an application for mandamus. But your lordship will see that on each occasion, whether it is mandamus, prohibition, or certiorari, it is because of the offending commission putting you in that position, because they have gone way past the time that would have been reasonable. And so the question is, what sort of expectation do you generate when you operate like that? And that's why they went the route of judicial review.
Well, I repeat, the expectation in your client's case is he expected that he would, in the fullness of time, obtain his registration certificate.
And during the period of time, my lord, that he would not be considered as he was being considered now.
Well, how can he think that? Because Section 70 tells him he's got to be registered.
My lord, well, we have explored that. It is because he understood from his employer and from the commission that once they filed, they would, as your lordship said, in the fullness of time. And the fullness of time, once it went into the 2 years, my lord, I can't imagine what would have been in the mind of anyone else, except that it would have been an administrative effort at that stage to grant the licensing. They went on for 2 years, and when the question was put to the full court, your lordship saw how the full court dealt with that. So there's been no serious treatment in terms of looking at the actions, the acts and omissions of the regulatory authority. And even to cite my lord, he said perhaps it's mandamus, and on each occasion you are being forced to think of what prerogative relief you need to draw upon in order to get the respondent to act. And it goes back to the question again, at some point in time it has cost him a fortune to pursue this, and there were cost orders against him. It was set up in a misconceived application, and yet we've had several instances of things that required some form of addressing. As I indicated, had he been successful in the lower court, it would not have been this odyssey that he has been set upon. Had the full court taken that view, secondly, had the Court of Appeal dealt with the validation issue properly, again, he would have been exonerated and relieved of this. But on every instance, at every term, not only did the commission take a certain view, they were joined by the court. Well, if I may conclude, because I believe we have explored all of it, it would only leave me, if I may take my instruction in terms. My lords, insofar as the order for costs was made against the appellant in the Court of Appeal, in the full court, we believe that our rules indicate that unless there's something unreasonable about your prosecution of your matter, there ought to be no orders to costs. I don't believe that the full court of Jamaica gave proper consideration to the provisions of the civil procedure rules as it relates to costs in judicial review applications. And we certainly saw where, at least on a minority view, that he was supposed to have had a hearing if there was an agency relationship between himself and money. And in fact, if there was no agency relationship, His Lordship, Mr. Justice McIntosh, said the appellant would have been correct in saying that he had no hearing. He then made no further comment. Had he stayed on that path, perhaps the appellant may have had more success in that regard. And I certainly believe that there was sufficient before the full court to make no orders to costs. By the time it got to the Court of Appeal, they were praying in aid of the Validation Act to save their actions of 2004. Your Lordships have made what I consider very appropriate observations regarding the enforceability of that act against the appellant, and yet rulings were made in favor of the respondent, costs reserved to the substantive appeal, and then once again, without calling upon the respondent to account for their relationship with money and how they came to have several meetings with money, followed by how they would proceed with this matter, to include locking the appellant into that arrangement, because it is exactly that, my lord, locking him in to the offer of a fixed penalty or face prosecution and additional regulatory sanctions. He says that he ought not to have been locked into that. He ought to have had the opportunity to make his own representation, perhaps to be persuaded by the Commission, that he should accept the fixed penalty, or to persuade the Commission that they ought not to look at it in that way. Both parties would have had the benefit of an attempt to persuade each other had the Commission proceeded. And at judicial review, the question would have been asked if the court had chosen to go there, whether it was the disparate strength of the two parties and the bargaining position of both parties. One had $3.2 million with the lodged in trust to the FSC. The other one did not. On judicial review, whether or not he was treated fairly. So, my lord, for all those reasons, we have asked that the appeal be allowed in whole and part, and certainly we rely on the fact that the Validation Act, my lord, was not in force at the time of the hearing of the full court, and ought to have been treated, the proceedings before the full court ought to be treated as a nullity by the Court of Appeal. And that in any event, as hopefully would have been ably demonstrated this morning, the appellant really should not have been condemned in custody. He is here because at each juncture, the court saw it fit to dismiss his applications. Unless I can be of any further assistance to your Lordship.
As far as the costs are concerned in the full court,
Yes, my lord.
we've got the order on page 118.
Yes, my lord.
Saying the issue of costs is reserved for further hearing. Was there a further hearing and a further order that we don't have?
No, my lord. In the full court, my lord, the order of the full court is actually to be found at. found at 117 for His Lordship, Mr. Justice McIntosh, and at 111, Mr. Justice Marsh, and there's a silence on the part of Mr. Justice Reed. Cost was ordered against the appellant.
So the order sealed on the 5th of December, it's just plain wrong, is it?
Is it on page 183?
My Lord,
Page 118.
yeah, the full court orders are at page 1. No, my Lord, if you look at the judgment, my Lord, this
183 is the Court of Appeal order, I think.
the judgment is what? Yes, if your Lordships look over leaf at page 117, you'll see where the costs were ordered by the full court, my Lord. Page 111 has it recorded, my Lord, and page 117.
I see all this. This is the judgment that was given on the 28th of October.
Yes, my Lord.
And I'm simply looking at the order on page 118.
That was a filed order, my Lord. I don't, maybe they wish to reopen the issue. Maybe they had wished to reopen the issue of the costs, but the judgment carries the cost order, my Lord. If you look over leaf at page 117.
The order doesn't carry the cost order.
This is the filed order of Palm and Walters, my Lord. I don't know that this was a signed
At
order.
all events, this is an unsolved mystery.
Solve it quickly.
But at the moment, your client's been ordered to pay the costs at both stages.
Yes,
is that
my Lord.
correct? And what are you asking us to do?
I'm asking that at the very least, my lords, that both sides bear their own costs. This is in the event that your lordships take a certain view and are left only with the matter of costs. But insofar as my submissions on costs is that if your lordships are not with me on the substantive appeal, that I would be asking my lords to consider that the cost order of the full court ought not to have been against the appellant.
And you rely on the rule which is recited at the end of a judgment of the Court of Appeal on page 215.
Yes, my lord.
Are the rules the same or different in the Court of Appeal?
My lord, I saw my learned friend's submissions that cited the Privy Council that indicated they do not extend to appellate proceedings.
So that the principles that apply at first instance for judicial review
may not be the
are
same.
different from those in the Court of Appeal.
Yes, my lord.
In the Court of Appeal, the general principle is that costs follow the event.
My lord, we are then guided by the principle of costs as they relate to judicial review proceedings, my lord. And in judicial review proceedings, things such as the conduct of the parties throughout the hearing also are brought to bear. The Validation Act issue, my lord, must impact in some way on the question of costs, because...
So I didn't follow that. My only question is the principle, as my lord pointed out, at page 215 we have the rule. Now that on the face is that it relates to proceedings at first instance.
Yes, my lord.
Is the rule the same in the Court of Appeal, or is the rule in the Court of Appeal in Jamaica that costs follow the event?
The rule in the Court of Appeal in Jamaica, save for judicial review, which I believe we're governed by the judicial review rules, would be that costs follow the event. But judicial review is special, I'm saying, my lord. Judicial review is a challenge to the public authority.
I understand all that, but where is the rule?
It's silent, my lord, in
Where
relation
is the
to
rule
that.
that provides the same principles apply in the Court of Appeal?
My lord, there is no...
But you're saying that
Yes.
Rule 56, 115 brackets 5, applies in the Court of Appeal as well as first instance?
No, my lord, I have answered. No, I have answered, my lord. It does not. It only applies at first instance.
Yes.
It only applies at first instance. What I was indicating, though, although the Court of Appeal rules make no specific provision, I pray in aid of the principles in judicial review that always consider the circumstances of the case at hand before making an order, as opposed to in party and party matters where the costs follow the event.
Yes, I think
I'm saying that the rules of judicial review are the consideration in making cost orders. It's not simply, as the Court of Appeal did, take it, cost following the event. judicial review, similar to almost like family matters. In Jamaica, family matters, there are no orders to cuss. And there's precedent for that because of the special nature of the proceedings,
Yes.
as opposed to party and party.
Well, thank you.
Very much, Madam.
What we will do is we will rise for a few minutes to assess the position, and I hope to be back in a few minutes' time.
Obliged, my lords. That's all right.
One must.
Recording. Yeah. Okay. You want us to go outside? Will you call us before they come in? Will you be? It's not. Where we won't go to?
Just find a door.
All right. Well, let's stay with
It's probably best if you can stay in. I mean, they're going to be breaking for lunch, presumably at 1 as usual. I've not heard otherwise. So it's probably best to. Every one of these meetings that are mobile phones are definitely off. We had 1 6 on.
Sorry, I met them in the corridor.
Right, sorry,
What are they doing?
They're having a short deliberation to consider things as of 12:53 by my watch. Then they're going to.
Yeah, it's all right. I just bumped into them on the way along. Okay, have they heard just the appellant, both sides?
They have heard the appellant.
Okay.
I don't know whether they've completely heard the appellant. I think they have.
Okay.
They passed the judgment.
Right.
Nor can they. I had to pass it up at both.
Right. Okay.
Lord Clark did.
What?
But I just inadvertently turned his microphone.
Oh, okay. They'll get used to that.
There's a number. There's limits to how long. I think Mr. Dunkley to the Blackburn illumination.
Yeah.
I think, to be honest, if we're not taking authorities and we are just relying on that, we should probably have some similar arrangement as we got for Lord Service. Everyone off button covered. We should probably turn them.
Well, no, you can't, because they need to turn them off if they're going to speak, or they need to be able to turn them on and off as they want.
There's bound to be. We could put it on a bit of tape and we could lift it up like a
No,
hinge or
no,
something.
no, no. Stay as it is. And stop worrying about the. Why are you worrying about the authority? We're not doing that. We don't need. No, we're. I said at the last resort. We have in all the years I've worked here, we have never.
No, not have I.
So you know, you don't need to do it.
What's happening yet? It's just. It literally could be just 2 or 3 minutes, you see. So the only. I'm sorry.
switch off.
Suddenly be at the door.
court rise?
Yes, Mr. Foster. There are one or two points that we'd like you to think about over lunch, Mr. Foster. The first of those, at least, is one that I will ask my Lord Collins to raise with you.
Yeah, it's this. It's the interrelationship between the Validating Act, the Section 70 of the Insurance Act, and the notice on page 22. The effect, it seems to me, of the Validating Act is to make the notice a document which has been issued by the Commission. But the Validating Act doesn't in any way affect the criminal liability of any person. So it is at least arguable that Mr. Lawrence has not committed any offence under Section 70 because, although he carried on insurance business as an insurance intermediary without being registered, he couldn't have been registered at the relevant time because the Commission wasn't instituted. Therefore, it may be arguable that even though the notice is a good document as a document, it contains matters which couldn't be true, namely that Mr. Lawrence has committed an offence or is liable to have criminal proceedings taken against him and has a liability to conviction for the offence. It is at least possible that it could now be said that the FSC has reason to believe that he's committed those offences, but that would only be, seems to me, on the basis that they were reasonably mistaken in law. And that's the point. All those points trouble me, and the conclusion might be that the notice, even though it might have been validated as a document by the Validation Act, is still not a good notice.
I will give you those points on resumption. I will give you those points on resumption.
Yes.
Yes, by all means. The other matter on which you may be able to help us, as we were discussing with Mr. Dunkley, is your client's attitude, whatever the outcome of these proceedings, as to the prosecution of the appellant.
Well, that has not been considered and is really not an issue at this point.
But I mean, do you have any instructions, or can you get any instructions as to what the attitude of your clients is towards reporting this matter to the DPP, whatever the outcome of this appeal?
I have no full instructions on
No.
that, but my understanding is that no steps would have been taken.
Yeah.
I will endeavour to get instructions.
See what you can do, and we'll come back at 2:05.
When you say that no steps would have been taken to prosecute the appellant, perhaps you'd explain later on exactly what you mean by that,
Well,
and on what hypothesis you're saying
the
that.
option that we're doing to the respondent is to report the matter to the DPP for prosecution.
Yes, thank you. Well, we'll resume at 2:05.